Oh, hey. No, I'm not a doctor. No, you haven't seen me playing one on TV. But I am a doctorate of law, and today we're going to discuss June Medical Services LLC versus Russo. All right, so let's jump right in. What is this case actually about? So this case stems from Louisiana Act 620, which was a law passed in 2014 in Louisiana that required doctors who are performing abortions in the state of Louisiana to obtain admitting privileges at nearby hospitals. And what the law said was this: every physician who performs or induces an abortion shall have active admitting privileges at a hospital that is located not further than 30 miles from the location at which the abortion is performed or induced. So, in response to the law, several abortion providers and clinics filed suit against the state of Louisiana in this case, alleging that it was an undue burden on a woman's right to receive an abortion in the state of Louisiana. A little bit of procedural history in this case. When it was brought, the district court in Louisiana found in favor of the abortion providers in this case, relying on whole woman's health, ruled that the Louisiana law was unconstitutional and it did unduly burden a woman's right to obtain an abortion under the Constitution. On appeal, the Fifth Circuit Court of Appeals reversed and stated that the facts and the law in this case were distinguishable from whole woman's health, and that in the case of Louisiana, the facts did not support that there would be an undue burden should this law be enacted, and there was no evidence in the record showing that a woman would have a substantial obstacle or undue burden if the law wasn't acted as it was originally written. In response, of course, the abortion providers appealed up to the Supreme Court, and that's where we are now. So before we consider this case, we need to consider the case that the Supreme Court decided in 2016, and that's the case of Whole Woman's Health versus Hellerstedt. And that case arises out of Texas in the Fifth Circuit as well. And in that case, the petitioners were challenging Texas laws which required, among other things, that abortion providers in that state were required to maintain admitting privileges at nearby hospitals, and that abortion clinics had to maintain the same standards as ambulatory surgical care clinics throughout the state of Texas. So the petitioners in that suit were claiming that these requirements were creating an undue burden on a woman's ability to exercise her right to receive an abortion under the Constitution in Texas. So the Supreme Court in that case decided that these Texas laws with these requirements were unconstitutional and that they did provide a substantial burden for a woman to exercise her right to obtain an abortion in Texas under the facts of that case, because the court reasoned that by enacting the law, it would require many abortion clinics to close, which would undue burden a woman's right to exercise her right to an abortion. Another important case we have to keep in mind as we discuss the current case is Planned Parenthood of Southeastern Pennsylvania versus Casey. And in that case, the Supreme Court held that states are within their rights to regulate the practice of abortion. However, that regulation by the state through state law or statute or however cannot place a substantial obstacle that would impede a woman from exercising her right to obtain an abortion in accordance with Roe. So that's a very high bar that Casey set, but the court in Casey did not define what constituted a substantial obstacle. So with that in mind, we can now discuss the current case. So the question in this case is, does the decision by the U.S. Court of Appeals for the Fifth Circuit, by upholding Louisiana's law requiring physicians to perform abortions to have admitting privileges at local hospitals, conflict with the court's binding precedent in Whole Woman's Health versus Hellerstedt? So the first argument presented by the abortion providers in this case is the legal principle of stare decisis. And under that principle, a court is supposed to follow its prior rulings and precedent so that there is consistent application of the law. And here, the medical providers providing abortions in this case argue that materially indistinguishable laws, once ruled unconstitutional, are all unconstitutional. So they're arguing that the Louisiana law has a requirement for admitting privileges, and that the Texas law also had a requirement for admitting privileges, and the Texas law, also arising from the Fifth Circuit, was found to be unconstitutional already, and therefore, since the laws are somewhat indistinguishable in terms of their requirements, they should automatically be unconstitutional on its face. And in support of this argument, they point to the fact that many states where these challenges had arisen with similar laws, a lot of those challenges were dropped, or the states stopped defending the cases, or stopped pursuing those laws in response to Whole Woman's Health in 2016. The state argues that stare decisis does not apply with respect to Whole Woman's Health because the facts of the Louisiana case are much different than the facts in the Texas case. And the state argues that the Whole Woman's Health case was narrowly tailored to the facts in that case with respect to what the Texas law said and what the effects of the enactment of the Texas law actually were. In this case, the state of Louisiana is arguing that the laws are very different, and that the Louisiana law, while it does contain a requirement that abortionists obtain admitting privileges at local hospitals, it doesn't have many of the other requirements or regulations that the Texas law had with respect to ambulatory surgical centers or other things. The state also argues that the Supreme Court should affirm the Fifth Circuit Court of Appeals analysis in this case because you can't get relief on a pre-enforcement action when the law has not been enacted and thus there has been no impact on anyone's constitutional rights in Louisiana. So they're arguing that under the facts of this case and under the Louisiana law, no one has suffered any undue burden with respect to their constitutional rights since the law was enjoined and never enacted in Louisiana. And therefore, there is no remedy for this court to give in this case to these abortion providers seeking this law be invalidated on its face because of the ruling in Whole Woman's Health arising out of Texas. The abortion providers also argue, by applying Casey, that any benefit received by the state in this case is not outweighed by the undue burdens imposed by women seeking abortions by enacting this Louisiana Act 620. But rather, the abortion providers argue that because of the enactment of this law, it's going to limit a woman's options to obtain an abortion, and it's going to force clinics in Louisiana to close, as they allege they did in Texas, and therefore the law on its face is unconstitutional because it's going to present an undue burden for women and a substantial obstacle for them to obtain an abortion because it's going to result in closures or possibly result in closures in the state of Louisiana, which would give an undue burden to a woman, which is prohibited by Casey and thus making the law unconstitutional. The state in this case argues that the Fifth Circuit was correct in its analysis with respect to whether or not an undue burden exists with respect to enactment of the Louisiana Act 620. And their argument is that under Casey, which is the case we mentioned earlier, that there's the substantial obstacle test is the proper standard to be applied, and that is not a simple benefit versus burden test that the district court applied or that Whole Woman's Health applied in the case of the facts in Texas. So they're arguing that the Fifth Circuit was correct after its de novo review of the facts, that no substantial obstacle prevented a woman from seeking to exercise her right to an abortion in Louisiana by the enactment of this Louisiana Act 620 law. So the state is arguing that without a substantial obstacle, there is no undue burden under Casey. So you can't have an undue burden if there is no substantial obstacle. And the state argues in this case that Louisiana Act 620, by requiring admitting privileges, does not create a substantial obstacle under Casey, and therefore no undue burden can be created. The state argues that essentially every law seeking to regulate abortion would be invalidated under the test propounded by the abortion providers in this case, because there would always be a burden versus balance test, and the state would never have an interest that would outweigh a burden that would be placed on someone seeking an abortion. So that is why their argument is the heightened standard in Casey must be applied as if there is no substantial obstacle, then there is no undue burden. It is not a simple burden versus balance test. In response to the state's argument that the admissions privileges requirement acts as a credentialing standard with respect to the competency of the physicians who are undertaking to perform abortions, the abortion providers argue that this does not serve any relevant credentialing purpose because there already is mechanisms in place through statutes and other regulations within the state to make sure that physicians engaged in the practice of medicine are licensed and that they are competent in the area of which they're practicing. They also state that the statutes in Louisiana already restrict what physicians can or cannot perform abortions, and therefore this admissions privileges law doesn't offer any benefits with respect to this requirement for physicians providing abortions. The providers also argue that this issue was already argued and rejected by the Supreme Court with respect to credentialing and admission privileges in the Whole Woman's Health case, and therefore it should be rejected again in the instant case. In response, that if licensure was all that you needed to show competency, why would hospitals need a credentialing standard? Instead, they could rely on a doctor's license for competency rather than trying to require that doctor to possess certain credential standards to have admitting privileges and a relationship with their hospital. A big argument for the state of Louisiana in this case is that the abortion providers lack standing to bring the case on behalf of their potential female patients. So their argument is there's an insufficient relationship with respect to the doctors who provide these abortions and the women who are seeking the abortions. And the state argues that there's not just an insufficient relationship and that the parties aren't close enough for them to bring the suit on their behalf, but there's also a conflict of interest in that the abortion providers and the abortion clinics have an economic interest in providing as many abortions as possible and having the least amount of regulation by the state as possible. So of course they don't want additional laws that would regulate their practice, but they also want as many females coming in as possible to have these abortions to make money. So in this case, there's a conflict, argues the state, between the economic interest of the doctors in having less regulation and many patients as possible, and the health of the patients, which the state seeks to regulate the clinic to make sure that they're providing safe medical care. And then because of that conflict, there isn't a sufficiently enough close relationship between the abortion providers in this case and the women who are not named as plaintiff in this case, and therefore the women are not hindered at all to bring the case on their own, and they should be the ones bringing this case, asking this court to invalidate the state law as unconstitutional rather than the abortion providers, because an insufficient nexus and relationship exists between the two where the abortion provider has standing to bring the case on behalf of a woman. So a huge piece of the argument by the state in this case is that this case should have never been brought by abortion providers in the first place. Women who are actually suffering a loss and an undue burden as a result of the enactment of this law should be the plaintiffs in this case who brought the case, and therefore the claims are not ripe to be decided by the court at this time, and then they should dismiss. With respect to the argument and standing in this case, the abortion providers are going to stand by the Fifth Circuit's decision that the clinics and doctors do have standing to bring these cases on behalf of their patients since a close relationship exists. The Fifth Circuit implied that the standing was proper for them to bring these cases in this case, and they would maintain that this should be upheld by the court as well. So now for the question, how is the court going to decide in this case, and what are my predictions on that? So I think it's going to be decided in one of two ways, and the court's either going to, one, say that the abortion providers lack standing to bring this case on behalf of their patients because there isn't a sufficiently close relationship between the patient and the doctor to allow them to bring these cases, and that nothing is hindering any of their patients from bringing a case against the state challenging the constitutionality of the statute under the principles of jurisprudence with respect to Article 3 standing to bring cases. If they don't dispose of it on those grounds, I think this is going to be a 5-4 decision upholding the Fifth Circuit Court of Appeals decision in this case and distinguishing Whole Woman's Health with respect to the application of the facts in Texas and saying that it's different in Louisiana. And I say this because if you read the dissent written by Alito and joined by Roberts and Thomas in the Whole Woman's Health case, this fits squarely with the arguments presented by the state of Louisiana in this case, and thus, assuming that no one's changed their mind since that dissent was written in 2016, and that Gorsuch and Kavanaugh are going to side with the more conservative view propounded in the dissent, I think that's going to be a 5-4 decision affirming the Fifth Circuit, clarifying the standard in Casey, which defines what constitutes a substantial obstacle, and distinguishing Whole Woman's Health as applicable only to those facts in this and law which were presented in the state of Texas. So that's my prediction. Again, doesn't matter what I think. Could be completely wrong, but we'll see. We'll probably get that decision in June, assuming we see what COVID does. So aren't we glad we're done with discussing the heavy topic of abortion? I hope you enjoyed the episode and that you have a clear understanding of what the arguments are on both sides and what the legal standards are with respect to these kinds of cases. And I hope you tune in for the next episode coming soon. We'll see you next time.